Hi and welcome to my video. Today I will talk about the law of agency, part 1. The content of this video will be the introduction, legal concept of agency, creation of agency, and termination of agency. Introduction. It is a general principle of contract law that only the parties to the contract acquire rights and liabilities under it. Legal concept of agency. In legal terms, agency involves three persons: the principal, the agent, and the third party. There are three ways by which an agency can be created: 1 by express agreement, 2 by implied agreement, 3 by operation of law. By express agreement, the appointment of the agent is made in writing or verbally. In formal cases it is done by a power of attorney which is normally stamped and registered. Example: a customer wishes to transact his banking business through an agent. The bank will require written evidence that this agent is registered under the power of attorney. On the other hand, creation of agency by implied agreement, there is no evidence that the agent has been appointed by any writing or verbally. Example: Payal, the principal, has paid Prasad, the third party, for goods sold on credit to Sunil, the agent. Payal had never disputed Sunil's authority to receive the goods, therefore, by conduct there is an implied agreement that Sunil was acting as Payal's agent. The third point of creation of agency is by operation of law. It is divided into four. First is necessity. An agent of necessity can be described as a person who, in circumstances of an emergency, acquires by operation of law a presumed authority to act as an agent. Pause this video to see the case of Leprague v. Burroughs, 1859, that described his necessity in selling the ship. Second is by marriage and cohabitation. A wife is presumed to have authority to pledge the husband's credit for necessaries in keeping with the social status, such as food, clothing, and medical attention for the spouse, and the children in keeping with the family's social standing, but this does not include luxury items such as jewelry. In the case of Payanta v. Macro, a trader who sold a wife a diamond ring on credit cannot claim its cost from the husband if the wife does not pay for it. Third is ratification. Ratification means that the principal adopts or confirms an earlier act done by the agent which was not binding on the principal, and some essential conditions must be satisfied. Example: on the 10th of January, Sunil, Payal's agent, purchases goods from Prasad on credit without Payal's permission. On the 20th of January, Payal tells Prasad that he will accept responsibility to pay for the purchases, although at the time of purchase the agent had no authority to buy on credit. The fourth point of creation of agency is estoppel. In the law of agency, if a person by words or by conduct represents to the world that someone is his agent, he cannot later deny that agency. Pause this video to see the case of Lloyds Bank Limited v. Chartered Bank of India, Australia and China, 1929. Now, after the creation of agency, there are terminations. Agency may be terminated by 1. Operation of law, 2. Agreement between the principal and agent. Termination by operation of law can be terminated which caused by death, or mental incapacity, or bankruptcy, or, if the subject becomes illegal, example, hire someone to kill a person. While termination of agency by agreement between the principal and agent are normally terminated by mutual agreement to bring the agency to an end, or by completely performing the contract of agency, or by revocation of the agent's authority by the principal, or by dismissal of the agent due to breached in his duties. That's all for today, and we'll continue on my next video on law of agency, part 2. Thank you for watching.